minutes have been submitted.
Not done yet.
Not done yet. There you go. We haven't been submitted by staff. I don't know, Aaron, we might have to fire you. Oh, sorry. Does everyone know that Ellen has been hired to replace Aaron? Welcome, Ellen, as full-time staff.
I had my money on her.
Very exciting.
Awesome.
Glad that you've accepted the offer to continue working with us. Okay, and I would like to make a quick adjustment to the agenda. The person who makes the agenda seems to be the most likely to do that. And the Trails group have a quick update on just the status of where they're at. So I'm going to are you ready for that, Jamie?
Yeah.
Okay. Jamie's going to give us a 5-minute update.
Yeah, and I made the request to you just on behalf of both conservation organizations and trail organizations. We've been meeting together, and Randy and Cindy are here. But there's been a number of conservation groups and trail groups that continue to meet on a regular basis.
Do you want to come up and...
Oh, sorry.
That'd be great. And actually, if Randy and Cindy can just say who they're... Introduce yourselves and...
Yeah, I'm Randy Richardson. I'm the chair of the Vermont Trails and Greenways Council. I work for the Upper Valley Trails Alliance.
Great.
And I'm Cindy Locke. I'm the executive director of VAST and the chair of the Vermont Trails Alliance.
Thanks. Great.
Jamie Fidel, General Counsel, Forest and Wildlife Program Director with Vermont Natural Resources Council. It's just a quick update to let you know that we're meeting on a regular basis. Been productive conversations. We're trying to identify a proposal that would allow for an environmental review process that's both efficient but looks at the role of environmental review of trails, and we know you're at the point of putting recommendations into your report, and it was our hope that there could be some recognition, as I think you've already heard from Commissioner Snyder, that we were hoping to be able to provide a report back to the legislature. And we actually proposed to Commissioner Snyder, suggested timeline that we thought was consistent with what he had talked about with Representative Dean at a previous meeting of how quickly could you do this. I think they had talked about doing it within a year. We had said that it would make sense to have a status report because we may have our work certainly done before a year, maybe even much sooner, within a couple months. So we're putting a status report proposal in that language.
So I'm not following exactly. So when would you have something solid for the legislature?
Go ahead.
Well, sorry, I'll move up so you don't have to turn around. Our hope is sooner than later, and I know that's not the answer you want, but we were thinking it would take a year, but we really think we've been very proactive meeting together. Well,
Starting now?
we've shortened that. We're really saying by March 1st.
Okay.
No,
Thank you.
you're welcome.
That's what I wanted to hear.
The year timeframe was just out of deference to a conversation I had heard between Representative Dean and Commissioner Snyder at a previous meeting, suggesting how much time would you need? Would a year be adequate? And the Commissioner, I think, saying we have a lot of things we're juggling, but yes, that would be. And so that was the only reason we had suggested a year. I think we've also recognized we're looking at trying to do it much quicker than that, and had suggested a March 1st deadline for a status report, which could be a final report, if not even sooner.
Yeah. And I'm wondering if our council could remind us what our responsibility is in this trails conversation specifically.
Well, the charge is in the draft report, for the record, Aaron Adler.
Great.
Legislative Council. It says on page 45 what the charge is, right at the top. You're supposed to include recommendations on issues related to recreational trail jurisdiction under Act 250 on or before December 15th. So that would be, you have 8 days.
So can our recommendation be that we wait to hear from the Trails Working Group or something like that?
It can be. The commissioner also gave us some sort of, we can look and see what specifically he brought us, but there was some language in there around things we kind of agree to in the current process. I mean, currently, trails can fall under the jurisdiction of Act 250, so by waiting, we're not going to change that.
This actually says that you shall evaluate the strengths and challenges associated with the regulation of recreational trails under Act 250 and alternative structures for the planning, review, and construction of future trails and networks and extension of existing trail networks.
guys looking at both mechanized and non-mechanized trails?
What we're trying to do is really just, it really just started out with not understanding each other's roles in Vermont as far as the conservation organizations not knowing a lot about the trail organizations, and the trail organizations not knowing a lot about the conservation organizations. So rather than having those discussions within committee, could we find could we spend the summer, which is what we've been doing, or certainly in the fall, meeting and learning about each other, so we could recommend, we're not looking at deregulating the entire system, we're not looking for, we are looking for something that's gonna preserve the landscape of Vermont and the wildlife and the waterways, as well as regulate a little bit more, maybe trails. Some of us, like VAST, we have very, very strict regulations that we follow in manuals and things like that, and there are other organizations that do as well, but there are smaller organizations that are starting up. So we're trying to figure out how can we build a better system for Vermont that takes out some of the redundant regulations of Act 250 because of the rigorous permitting now that has to take place with stormwater and wetlands and all of that, which you've heard about from other groups as well. So we're trying to find, and we're finding a balance between what's, it's really folks from the Forest Partnership and folks from the Vermont Trails Alliance, and within those two groups, would you say?
Our motorized and non-motorized interests.
Yes, we're all working together.
So you're gonna be able to, can you give us some language? Summarizing where you're at and what you're kinda asking for around March 1st?
I think that's certainly the hope.
You're not asking for it by March 1st, you're asking for language.
For
in the
our report, to put into our report by December 15th, a
We
status.
submitted that to Commissioner Snyder, knowing that he was the person who was representing
that's what
this
we already
interest
gotten from him.
with the board.
Okay.
So there was, suggested language on a
Yeah.
time frame, and that we were continuing to meet.
Okay, so
I-
that's still the same,
Yeah.
okay, great.
And I think, as you know, he submitted a report to you, which included some input that we had all provided through a stakeholder meeting, and so you do have that. I think it was just our hope that, before moving on concrete recommendations, that we would have the opportunity to give you our best thinking and not have legislation moving at the same time that we were trying to give you our best thinking on the idea, on that proposal.
Right, okay,
So
great.
if it's not that this committee has that language, it'd be helpful to know where, what document, if I'm supposed to
Yeah.
find something, put something in the
I
report.
think it's under
'cause I
Michael
don't know.
Snyder on the witnesses.
Okay.
That's where I've seen it. Yeah, I think that's the latest. Great, thanks.
Thank you.
Okay, thank you.
Could I just interject on that topic?
Sure.
Really concentrate agency and natural resources. I think what the commissioner provided to you yesterday was both the language from this group and then also the recommendation that there was a number of.
Great time out, we're all looking blank. Something was submitted yesterday?
I'm sorry. I thought I saw there's an email that went to you from him yesterday that had the aforementioned language. So.
Did that go to all of us?
No.
Yeah, all right, well, so thank you for drawing that to my attention, I
So,
haven't seen that. Yeah.
And to just clarify, there's language regarding the work that these folks are doing. Then there's the acknowledgement that under the current process, we've determined that there's a number of terms and procedural aspects that aren't particularly clear as they relate to trails. So a firm recommendation or a concrete recommendation for this group is to direct the state to help clarify that ambiguity.
And that, I think, is in Michael's original submission.
Yes.
Okay, yeah, I remember that. Thank you. Great. Okay, here we go.
Is anyone on the phone?
Tom Little, I think, is on the phone.
Tom, are you with us?
Sorry.
Okay, great, can you hear us?
Yes.
Okay, we can sort of hear you. Okay, thought we would sort of pick up where we left off last time with the, hopefully everyone has it.
Can we,
The document of recommendations that we were going through, and I had side by side the VPA recommendations also. So recommendations submitted by a number of our advisors were lumped into this document. And we're starting section 4, Act 250 process, interface with other permitting and appeals.
It's this one, right?
It's like,
What page?
well, unfortunately,
Where is that on the right?
it's this document that has the lumps of recommendations. It should be from the last meeting.
We need copies, we need copies of the,
It's my thing that I
your
submitted
thing?
with the recommendation.
Yeah,
We have,
And then we have Planners Association recommendations.
do you want copies of
we
all
have
of them?
copies.
We should, everyone should have it from last time.
They're all online.
I didn't bring it.
Chris found his, Paul needs one, and Dick needs one.
Okay,
Thank you.
Can you, before we dive in, can you help, to me it would be valuable to understand, are we trying to identify the last couple of questions? Are we trying to come out of this, what do we, by the time we adjourn 4, where do you want us to be?
I would like us to be through the majority of the recommendations that are related to our legislative charge,
Okay,
and possibly circling back and reviewing the ones that Aaron has put into the draft report. So the way the agenda reads is we would finish task group 4 this morning, maybe,
okay,
and then move into reviewing the draft report this afternoon,
okay,
and get as far as we can get.
thank you.
Okay. So this picks up, it's page 6 in an unnamed numbered document. What page is it? Process, interface with other permitting and appeals. And, want to, okay, make sure. Peg, I'm gonna count on you to keep us on track again with the planner recommendations. Yours starts on page 13 of the planner's document. So,
What is that?
it's the printer. So, 4A was application and review before the district commissions the role of the NRB. We did not get, well, I didn't find any, when I did my lumping, I didn't lump anything in there. You look confused.
I was just trying to figure out what document you're looking at. It's
We are-
your summary of the recommendation.
Yes. And Jerry has submitted something just today. Where's Jerry? Oh, there you are, sorry, right. So I guess you'll pipe up when we get to something that's relevant to one of these headings that you've submitted to us for today.
Yeah, I updated the data on the appeals,
Okay.
and I outlined some of the cases that seem to fall outside the guidelines and explained why they were a little unusual.
Great. So is some of this stuff you've submitted before? So when you say you've updated it, it's...
What we did was we took all of the cases that I had submitted back, I think in April, are included in this. So this brings you up to speed with all of the cases plus the ones right up to December.
Oh, okay, great.
Okay, including anything that's been filed. We even found something on December 4th, but it takes it at least through the end of November.
Okay.
We send that to you.
It's in your pile right here. It was a physical drop. Okay, so structure of the Natural Resources Board. First recommendation is require that district commissioners have training or expertise in issues related to Act 250, such as environmental science, engineering, law, land use, or economics. I think I might read all 3 of the recommendations in this heading here. Pay district commissioners for service beyond a per diem. Consider making the chair a part-time job in recognition of the additional work a chair must do. So those are all VNRC. Better staff the district commissions with enough district coordinator support, administrative support, and legal support. keep the district commission process open and accessible to the public, ensure that Act 250 remains a citizen-based, applicant and participant-friendly process. That's VPA, and we've heard that also last week at the end during citizen testimony from John Brabant from Vermonters for a Clean Environment. What is the pleasure of the commissioners? You guys have copies now?
Yes.
Right. Require district commissioners have training. First one. So that's a good idea?
No, I said it's a bad idea. I'm teasing.
It's too early to joke.
Yeah, all right. I'll be serious.
Afternoon, we'll take jokes. Aaron?
I have a question. What does it actually mean? The governor cannot appoint someone unless they have that training? Is that the recommendation?
I don't think it was that blunt.
Well,
VNRC
what does it
folks.
actually mean?
Wait, what does it mean to the VNRC folks around John Grosvenor?
I mean, I think part of it is that there should be qualifications, just like there have been for, I think, board members. I think when the NRB was created and there was a water panel and there was a land use panel, I believe that there were, maybe it was a should and not a shall. But I mean, I think the idea is it's not too hard in Vermont to find people with some level of expertise. And it's just across from business, environment, planning. But the idea is things have gotten more complex, and you want people who have some, some minimum qualifications to do the work.
Has there been a concern that we've had unqualified commissioners serving? I guess I'm curious if there's a.
And there's a range of people, and everybody works hard. I think it just goes along with the idea. I've seen when I was chair of the NRB, we had some people the governor wanted to appoint and decline because they saw how much was involved and that they didn't really feel that they were qualified and to do what was needed. And I respected that. I thought that was a really it's not an easy decision to say no to a governor even after saying yes. But, people go through the training and say, whoa, this is more than I thought it should be. But the idea is, so the question is, given where we are today, do we need people, do we need to have something in about qualification?
Right. And training.
Can you reference the training, and this is my question anyway, can the board, what happens when somebody gets appointed as a commissioner? Do they go through logistical training? I'd like to hear from the chair or from council about what the process is in terms of training. Is it just on process, or is there expertise training, or just on the law, or what do commissioners get?
The governor appoints all of the commissioners, and when we are advised that somebody has been appointed, we work with them to do training, and we do continuous training, updates, etc.
On the subject matter expertise, or just on the law of Act 250, or on the
All
process?
of the above. We try to bring forward, current issues for discussion, etc. We would obviously like to start doing more as much as we can, but I think we have a pretty good process in terms of keeping people up to date.
But there's no formal training at a certain time of year or in a cycle of new people.
Well, we get new people assigned at sort of odd moments, so there isn't a particular time of year when new commissioners are appointed. So we do it when we have 3 or 4 people, then we do a training.
Greg, did you want
No, I just wanted to make sure that the commission did understand that, just as the chair articulated now, we do have not regular intervals of training, but when we have sort of a critical mass of new appointees, we do a formal training, usually for a half a day that covers all things Act 250, everything you could imagine. And then we do our best to include continued training opportunities going forward throughout the course of the year in various forms.
Peg, did you want to add something?
Well, there's added details that the planners put in there, submittal to you, and they may be covered already, I'm not sure, by the training. But, that includes,
Tell us what page you're on in the planner's document.
page 14, the second bullet, to include, the protocols for resource identification and what goes into a required impact assessment, what kind of impact assessments can be required. And on the planning, getting more training on planning and technical guidance, but it's really an appreciation for using graphic illustrations, having training materials that show you how to use and interpret plans and maps, site development, mitigation, and management techniques, just to make it, easier to apply.
Aaron?
Just fun, you should be aware that for the board appointments, which are by the governor with the advice and consent of the Senate, the statute now says that the governor and the Senate shall give consideration to experience, expertise, or skills relating to the environment or land use. That's for the board. The district commissioners is just appointed by the governor, and there's no particular specification. But
I guess
but this is, I also want to point out the language is give consideration for the board.
Yeah,
and
not require, right.
that doesn't mean you couldn't require it,
Right.
just you know what it says now.
I'm kind of inclined to sort of formalize the training requirement, or making sure they get training.
But they do get.
Yeah.
To what end? To make sure that they get
Training.
it. But they do get it.
They might get it right now, but I think that
I see.
administrations change over, and I think requiring training of district commissioners is a good suggestion.
I think to diminish the role of a citizens commission as opposed to some professional.
I think.
I think, as was pointed out, that you felt you weren't able or had the time to do it as a citizen, you wouldn't step forward. You wouldn't take it. I'd rather have it on that level than having requirements, prerequisites, become a member.
Dick?
Yeah, I want to protect the notion of a citizen panel, getting back to original intent, which is not dispositive, but it is persuasive. Though, when Act 250 was developed, there was a reluctance to hand important decisions off to bureaucrats, even though they're the ones who are the experts, and they're the ones who know what they're talking about. And the idea, and this happens to the legislature as well, you have expert witnesses talking to novice decision makers. And one of the duties of the expert witness is to express his or her expertise in such a way that the novice can understand it.
Yeah.
And that we don't have to be expert. I mean, I've always said my qualification to be in the Senate is that I can eat 3 church suppers in one night. But
As long as we're clear on that.
but you have to, and I played it every way. I played guitar in every way.
I think we're on the same
But what I'm
page.
saying is, yeah, you need commissioners who are intelligent enough to understand expert testimony in a field in which they themselves are not experts.
Yeah.
And I think if we make it more specialized, serving on the district commission, then we lose some of that community.
Yeah, I think we're in agreement on that part of it. How do folks feel about requiring training on Act 250?
Well, that's ongoing already, isn't it?
In an ad hoc way. It's not formal. It is formal.
Well, excuse me, Madam Chair, but I don't know what you mean by formal. We do train every commissioner that is appointed.
With a process that's the same for each commissioner?
Yes.
Okay. Okay. We're moving on. Pay district commissioners for service beyond per diem. Consider making the chair a part-time job in recognition of the additional work a chair must do. Per diem right now is $50 plus mileage.
Would it be, I'm not closed off to this idea, but I just have no real sense of what the current budget is and what it would mean. I would guess that it's sort of the per diem is not a fair evaluation of the work involved. So I'm sort of open to exploring this, and I wonder if it's, I don't want to punt on everything, but I wonder if it would be appropriate, given that we haven't dug into this particular item, for us to just say it's worth exploring.
So we say just
If
say-
the budget,
What about consider?
yeah.
So, I'm gonna.
Just for what it's worth, I left,
Evaluate?
when I became a state senator, I left the district commission
Yeah.
in 1989, and the per diem was $50.
I think that's why it's here. Right.
And
Right, I
at the
mean-
time, I kind of wished it was a little more.
Yeah.
But I mean, we can't, I agree with that, but I don't know if we should double it, or,
Right.
you know,
So maybe the word
how
should
to
be-
evaluate it in the tight time frame.
We don't have, so I think maybe evaluate or consider. Which do you like better? We gotta keep this, we gotta get the train on the tracks here. So, consider, that's the language, thank you. Better.
GA should consider the General Assembly?
Yes. General Assembly should consider.
Yeah, I mean, it's a report to the General Assembly, so I assume that means it's us.
Just double check it.
Okay, I don't know. All right. Better staff the district commissions with enough district coordinator support, administrative support, and legal support. Page 6 of an unnumbered document. Oh no, maybe it's numbered now. Number it? This
Your
is-
document?
This is our document, not the planners. You're in the planners. Planners is numbered.
They're good at planning page numbering. I wonder if, it certainly strikes me as a reasonable suggestion. We've kind of heard that the level of expertise is only intensifying, and complexity of applications, but we also know that applications are, there are fewer of them than, except for sporadically, right? I think we've heard that consistently. So I guess I'm wondering if there is a role to charge the board with some, to understand better how they're providing support and expertise. And if that is something that we should articulate, the board will no doubt have thoughts on the matter. But I would be hesitant to add staff at all the commissions, but I guess I wonder if there's a centralized,
Well, I
if
think
there's some ability to do that, centralized.
over time, there's been a decrease in the number of district coordinators that are, and sort of a grouping of them. And Diane would like to speak to this, so we'll let her do that, but I think that in part this is, it's not saying we need more, it's saying like, we don't even have the base load of the original, every district would have a coordinator. Diane?
Yeah, I mean, I just want you to know that every district does have administrative support, and they always have access to the attorneys in the central office, and we encourage that. So there's quite a bit of support for the district coordinators, if that's the question.
But does every district have a coordinator?
Yes, every district has a coordinator. If you mean a separate coordinator, the answer is no. But do they have a coordinator who is there to handle the workload in that district? Yes.
And the coordinator is out of your office?
No, but they're in 4 district offices.
I see. And some of them are shared.
Right.
Yes, some of them handle more than one district because the workload in those districts is what justifies that amount of time. In other words, you could have more coordinators, but then they would not have enough to do.
And now there's a floating coordinator, is that true?
There's a state coordinator, is that what you're referring to?
Well, I don't know, do they fill in when things get busy in different districts? Do you
That's part of the job, is to do that, among other things, so.
And has that been utilized since it started? Like, has that person actually gotten involved in reviewing?
They've just started as a state coordinator.
So that's sort of a reorganization.
Yes. It's a way of handling the workload and responding to ebb and flow of projects.
Yep. So, I mean, one of the things we hear from the development community is time. This takes a lot of time, and if you don't have enough staff, that's part of what makes it take longer. And so I want to make sure that the NRB is adequately staffed.
Yeah, I would like to dispense the notion that anything in terms of time is due to lack of staff. That simply is not true, okay? we've worked very hard to reorganize, to make sure that everybody has the work that they need to do and the work gets done in a timely fashion. I do think a lot of people try to project onto the Act 250 process many other processes that are included in it, as you have heard also. In other words, but it truly is not about staff time.
John?
So, I mean, this is just when I was chair of the NRB, I was personally frustrated that the budget, as you guys know, is continually, it's not going up, it's usually being cut. And I was asked, I was only there for a year and a half, I was asked, I think, 3 times to find cuts at the NRB. And we lost some coordinator positions in districts that were busy districts, that it was really hard to balance. You know, we did some reorganization like Chair Snelling has done, and you do what you have to do to kind of keep the system going. But I think a real look just needs to be kind of taken objectively on the resources we need to make the program run as well as it can, not go crazy, not, you know, blow it up with, you know, a ridiculous amount of staffing. But there's just no doubt that there are some districts that didn't have shared coordinators that do now, and that I think are busy districts. And I would hear from the staff that this is going to hurt. This is going to be a hurt on us in terms of the workload. So it's a budget issue, I think. I'm not sure, you know, how to recommend this commission deal with it, but I think in this budget process, I think it's good to look at kind of the staffing and get testimony and hear from other people. But I mean, things have gone down. They haven't gone up in terms of staffing over the years. There's just no question about that.
If I may, I just would like to add, if you choose to give any more appropriations to the Natural Resources Board, you would not specify that it go into coordination. In other words, you know, if you think that we deserve more money, please work with the board to figure out what you think it should go for, because I am absolutely convinced that what we have done is try to make sure that there is sufficient people to service the applicants and to provide to get the work done. So I mean, I can't be emphatic enough that that has been a priority of mine, and I feel very strongly about it.
Thoughts from the commissioner? Paul?
I was just wondering if you're getting complaints from the regional commissioners in terms of being overworked or not having enough resources to do their job. Is that coming down to you as the chair of the board?
Regional commissioners?
Yes, the people who serve on these Act 250 regional
The commissions, the
Yeah.
district commissions?
Correct.
No, I'm not hearing that.
Okay, so we'll let that one go now? All right, keep district commission process open, accessible to the public. Great, how does it, I think that may come up later. That may come up later with other suggestions that we look at, permitting, overlap, that's that category. But
I'm wondering if if anything here is open, it's based on the concern about how hard or easy it is to obtain party status and participate, and also to retain party status. There's a whole bunch of provisions that are in the statute about this is what you gotta show, and then the district commission re-examines your participation at the end. And I don't know if any of that was what is raised here, and maybe the answer is none of it.
John or Jamie from VNRC, this is your, was what Aaron just said accurate?
Can you repeat that half question?
Well, I was wondering if this is related to how hard or easy it is to obtain party status, to retain party status when it's re-examined at the end of the proceedings, any of that, or does it have nothing to do with that?
I mean, party status, it really wasn't, that was not in the front of mind with this recommendation. It was more the ability to put on your case, you know, come in and present evidence, and not in an overly legalistic, you know, environment where there are lots of objections and inability to really kind of let your concerns be heard. You know, if it was too rigid of a process,
I'll let Jamie, I don't know, party status was
Well,
really where it.
I think right now that the way it's working is we feel there was an improvement based on a decision in a Walmart case that defined, sort of clarified that party status wasn't as onerous as a previous decision had made it to be. I think that was the Pion decision, where you almost, in order to get party status, had to almost show that you were put on enough evidence to show that you would have an interest that would be affected and almost prevail in the case. So without getting into that legal test, I think it was just to signal that more or less if there were proposals, to go back and make it harder for individuals to participate at parties, that we were hoping it would still say more accessible along the lines of what the party status test is now.
So it's okay now, don't make it harder.
Definitely don't make it hard, in our opinion, yeah.
Okay, all
Some
right.
people may, yeah.
We are, I got it.
Well,
Go ahead.
there may be a difference between environmental organizations receiving party status and standing as opposed to citizens that are not adjoiners. So I'd ask that you understand there is a difference, and there may be a difference in the level of standing they're afforded by the Act 250 commissions. FYI.
Okay, so, I support this recommendation, but I don't think it needs to be in the report. I think we should keep it in mind as we evaluate some of the other proposals. What do you guys think? Okay.
What is the status now of materially assisting friends? Is there even such a thing anymore?
They do not exist.
They do not exist.
You can be a friend of the commission. The distinction is that a materially assisting party was a full party with the right of cross-examination, the right of appeal. A friend of the commission does not have the right of appeal and also may not have the full set suite of rights that exist for other parties. Like they may be admitted only to file a legal brief or to put on some specific testimony. They may or may not be given the right of cross-examination.
So what's the level of personal involvement as opposed to just simply being a concerned citizen that a person has to meet to become a party now?
You have, if you're an adjoining property owner or other person, you have to show that you have particularized interests protected under Act 250 that will be affected by the outcome of the proceeding. That's what the law says.
Yeah.
How strictly each commission applies that probably depends on the commission.
Particularized.
Yeah. And also, at the end of the process, the commissions are required by statute to re-examine party status, which I think is intended to say, well, if you didn't participate enough, or you just didn't show you. I'm not actually entirely certain why it was put in there, but I think its upshot is to possibly take party status away and therefore appeal rights away.
Okay, are we ready to kind of move on? There's one more bullet here. Ensure Act 250 remains a citizen-based applicant and participant-friendly process. Motherhood and apple pie. Is that a recommendation? That's sort of
No, that's, don't move away from the reminder.
reminder. Okay, I would probably want to leave it in. How do you guys feel?
Well, I mean,
I don't know if it's a recommendation.
since we're not suggesting to change that, is it?
Yeah.
No, it has a mom and apple pie quality. But on the other hand, that's where a lot of the complaints focus on, exactly that. You know,
The
keeping
feeling
it.
that it's not enough citizen base.
Well,
yeah.
Governor Douglas used to routinely refer to people who were concerned with Act 250 as special interests. You know, if you were concerned about the environment, you were a special interest. So there was that complaint. And then there's the complaint of people who are concerned that it's too difficult to participate.
Yeah.
So, that's really where a lot of the bones of contention show up. And this is more or less the mom and apple pie underlying assumption. So what we make of that is really, I think, probably the biggest work we'll be doing.
Okay. Oh, yes, Annette.
Annette Smith. Could I speak to the party status issue? With the requirement that you have to have a particularized interest, it almost, if there's a big case, it sort of becomes a hunt for adjoiners. And the problem is that if there's a rare or endangered butterfly that people care about, or bear habitat that people care about, that you really can't get party status on those things now. And so you have to be an environmental group to get in. And so it does, there is a level of the rules right now that undercuts the ability of Vermont citizens to individually protect the environment.
And the solution is to clarify the, I don't know if there's is there a definition of particularized interest that's being in use
Maybe
right now?
Aaron has some ideas, because this is a problem that, I mean, I heard a really brilliant presentation on this topic by the man from the Audubon Society in Rutland one year when there were hearings about Act 250. And he said, how do we as citizens go ahead and protect this? So,
Do you have any thoughts on that, Aaron?
Well, there's case law on what a particularized interest is, and actually, I think the Huon case that Jimmy mentioned might be part of that, but I don't have any particular ideas on how to change the standard for
Okay.
who a party is.
Oh, Peg.
Well, no help on that, in answering that one, but just a couple more recommendations on page 14 and the third bullet of the Vermont planners on improving public engagement. One is to, and there's been successful experiences with this, the pre-application neighborhood meetings on major applications, to really get input from people on alternatives and what's happening in there. And then before you get to appeal, having mediated design charrettes that involve all parties to really work through the details of what could be done on that project to satisfy people.
So when you say there's been some pre-application meetings happening already, is that, how does that get decided from the NRB's point of
I
view?
don't think it was from the NRB, I think it was
The applicant.
initiatives by the parties and the applicant.
They did it on their own, outside of the process?
Yep.
Yes. Aaron?
There is an option in the statutes for, here, for a scoping process to occur with A&R and the district coordinator. And an applicant can initiate.
I'm sorry.
That exists already?
It exists as an option. I think it's at the applicant's option.
Never been used. But it does exist.
I don't know whether it's been used. Okay.
How about the
I only know it's in the statute.
The NRC promoted it a decade ago when it got put in.
Yeah, I think it's a good idea, that's why we voted it.
But it's only for A&R.
I think you could explore whether to require in some cases that the scoping process happen and that include Act 250 for this already.
There has been a lot of debate over the years about scoping and these type of things, and they've all been voluntary, and I agree, because you know, it's up to the applicant. In A&R and their recent changes to their permit rules, they have tiers of permitting, and I think there's something in there about for like large projects having some sort of like initial meeting or something like that. That's how, and I think that's an interesting idea based on the complexity and the interest in a project. But so, I don't know if it's been used yet or not. But the idea is to get people together early to try to.
And the question is, do we want a recommendation that that sort of thing be required some way, or do we just want to encourage it?
Or, but I'd like to understand if there is any option right now for district commissions to require something like that. Or is it just, you know, the chair of the commission makes a suggestion and the applicants kind of hear it as a strong suggestion? Or is it never really happened? Anybody know?
Does anyone know the answer to that
It's
question?
in statute that it can happen.
What'd you say?
It's in statute that it can happen, that they're, that
So it can
coordinators.
happen that a district,
So-
a chair of a district commission could require the applicant to do that.
I
That's
think what it
required.
can happen that an applicant can ask for the scoping process and that it can include both A&R and the district coordinator. So it can be, but it's at the applicant's request.
We found that going in doing this, we found that if you're philosophically opposed, we can't technologically meet your needs.
Yeah.
I mean, I'm being straight. That is correct, Aaron is correct. When we ask for it, it's just really good to get a layout and get everybody's flavor of where the big check marks are. So I would keep that as an open option. I think it's good for all parties. It's good for the development process to be able to come in and be reviewed in advance, not in a formal setting, but just get the check boxes and going forward.
So is there something we could do that would improve it, or is it?
I think it exists,
It's never,
but I don't know if it can be improved. I guess if the developer asks for it, I've never been denied.
Right. Peter?
Peter Gregory, Two Rivers, Ottaquechee Regional Commission. It's an open option, but it's never been used in my region, and I think it's, in other states, it's been kind of a requirement for a pre-development conference, and it's a good thing, as you indicated, but if it's not used, it's a no thing. Coupled with that, when you have joint jurisdiction with local planning and zoning, and then you've got Act 250, I've seen, tons of money spent to get local permits when another party like the Regional Planning Commission's not even involved in that level. And by that time, there's so much money spent that redesigns are not desired by anybody, but I think at a certain threshold, a required pre-development type conference would be useful. Because again, an option is not working.
Yeah.
I couldn't agree more. For example, in the local setting with DRB, that's almost a prerequisite to go in before, have the meeting, talk it out, everybody's on the same page and you get a flavor. I think it would help expedite the process and actually be less expensive, because some people are just gonna drop out, going, whoa, this ain't happening. Or thinking there'd be a lot of opposition and saying, oh, there really isn't. And yet all the players at the table, when we've done this with A&R and with the whole system of people. It actually is, it's not used very often, but it's something that when it's done, I've never seen it not be beneficial. It expedites the process.
Peg?
And I think, Peg Hoff for the Vermont Planners, the piece this came up at the conference in those interest groups that broke out in the afternoon. The thing that I don't know is I'd seen happen or was as thoroughly thought about when you say all parties, to make sure that the local decision makers are involved as well. That you don't separate it into two silos of the Act 50 process and the municipal process.
And so one of the things that we're, I think, grappling with is like, well, whose responsibility is that? Where does it come from? So yes, we've just heard very compelling reasons for everyone to show up early on in the process and have a conversation.
This is what I intend to speak to during public comment, because there doesn't seem to be any other place to do it. So to discuss how to formalize a community-based stakeholder process that does bring everyone in as an alternative to a contested case before the developer has put all the money into the engineering and everything, and then there's joint fact-finding where the money gets spent by the developer but everyone agrees on it. And I can elaborate on that further, but it's something that I think is long overdue in Vermont, and that we shouldn't just start every development with a fight, and that we need to create this opportunity, and I have a more thought-out proposal.
Right. I think that's what we're talking about right now. The gentleman in the back?
Yes. Thomas Weiss. I'm a citizen. I got involved in one Act 250 process, but what I'm hearing, I think, with this pre-conference is this going to be something that's going to be more difficult for citizens to participate, because it's going to be more difficult for us to find out about them, and then we don't hear it until the application is formally filed and notice for the Act 250 permit, and then we show up and it's, well, why weren't we at the pre-construction or the pre-conference?
And a more formalized process would involve the typical notification process.
Right, so can you just cut to the punchline and just tell us who do you think would coordinate your formalized process? Who?
The coordinators.
The district
coordinators, it would be, they would
Yeah.
be trained as facilitators. The Consensus Building Institute is happy to help with the training. It is something that's done all the time now, and it really cuts costs, it makes it more efficient, and it results in better projects.
And to Mr. Weiss's point, I think it would then, you would be including the local review commissions, DRBs or planning commissions, so that would really be their obligation to make sure their citizens, it was on their agenda, or however you got notification now. I think it's a valid point. You wouldn't want the process to go so far without the citizens being aware of it, but
Act
presumably.
250 is very good at notification, and so it would be the same notification process for the project, but it wouldn't be for the typical pre-hearing conference.
Right. Okay, I'm inclined to include a recommendation around this.
I would agree, but I would say, you know, as Ernie mentioned, the DRB and Burlington's already doing this, so some way to fold them together where it makes sense or something. I don't think you need to layer it on top. That would be something to just watch for.
Yeah, I think that's the idea, is to bring all the review bodies together with the applicant and hopefully interested citizens.
And you actually don't get to Act 250 till you've done the local process.
Right.
So it's almost you're carrying the paper to this meeting. Remember that even though they come together with regional planning and local, the Act 250 is a standalone element. And so, but what I would also, because I think we're kind of on the same page ironically, is that there should be a threshold. There are dozens of projects that are additions and nobody really cares. If there's a way to evaluate that so you don't waste time of the staff and a lot of meetings for no purpose.
Right. A certain size of.
A certain, yeah, and I don't know what that is.
Right.
And that is subjective, but I would tell you that if there's anything that's controversial, then that really should have but there's a threshold that seems to me, looking at all of the applications, there's perhaps a little bit of subjectivity here, but there's stuff that really I don't think will benefit by it because it's going to go through the process anyway.
Right, right, I agree with that.
And this can get timely and complicated because everybody has to meet.
So I think our recommendation could summarize the concept, and we don't have to, we're not gonna iron out what Ernie's point about the scale of it would be, but somehow it would need to be addressed, and so included in the recommendation. That makes sense.
Include the vague concept in the recommendation.
Yeah.
I presume this is not a problem, but I just want to verify. The end result of the meeting, of all the consent, is not binding on the commission. We gotta make sure.
Right.
that's-
Right, thank you, that's a good point.
Because one side might give away something that's really not theirs to give away.
It's purely informative for both sides, but I find that it goes a long, long way to understanding the texture, the complications, where the trigger points are, and who you have to meet to resolve the standing issues. Whether it's it's a neighbor or if it's part of an A&R that we missed. It just highlights.
Well, legislative committees do this all the time.
Right.
And we tend to be very deferential to the result. You know, the landlords and the tenants get together on a tenant rights bill, and they come in and everyone's fine with this.
So are the commission members present agree we could have a recommendation around this idea of a stakeholder conversation process?
Being a requirement, assuming it's a new project or some threshold that we'll figure out, or somebody will figure out.
Yes.
We let them figure out the trigger.
Well,
Well,
we'd have to figure it out when we,
if the bill moves.
if the bill moves through committee with it in it.
Yes,
But we're supposed to write a bill, so.
All right.
Special TBD.
Yeah, understanding that it will require, the definition of the threshold.
It occurred to me that you could give the district commission discretion to say this application should have this, or parties could ask for it. But that actually assumes that they filed an application.
right.
And what you're talking about here is something that I think people want to have happen before the application is even filed, so I don't know how.
Or a pre-filing on it.
Billy?
The Public Utility Commission requires 45-day advance notice of filing an application for most projects, and we find that's a helpful way to make interested parties aware of something that's coming down, and that could be, for certain scale projects, another way to kind of trigger what you're talking about.
Ernie, I have a question for you.
Sure.
How often do people who are proposing a good-sized development, new development, just start local and see how far they get
Correct.
before
That's-
they even go to active?
That's what I was going to say,
Yeah.
because I think to Aaron's point, the reality is you don't want to have a lot of time expended in the local areas just to test this out. You test locally,
Yeah.
okay? That's where you're all in, and that's where you have these pre-development conferences. I would say that the only time you'd have a pre-conference, Act 250, you've got to pretty much be there. You've got to have walk through A&R with all the people. You've got to have pretty much your plans ready to go. I don't think you want to waste, because you spent all your time knowing you have a project locally, and now you're carrying it to the state review. You have most of those items, and I would say that the only time you have a pre-development conference is when you're pretty much there, so that you're not wasting time of the state or a lot, because there's a lot of agencies that come in and do this. So I think that it's almost like a pre-Act 250, whether you've had to file or not, but I think you've got to have, pretty substantial material. And you're going to, because you're not going to do this unless you've had local.
Well, I think that's why I kept asking who convenes it, because I don't necessarily think that the district coordinator, they might not even know the developments in the pipeline,
Well,
right?
I think you have to apply, you have to present your, for example, my argument has been timing is that unless I get my 25 letters, I don't have a formal application. But when I have 90% of them, the others are just formalities of time, that's probably a good time. It's when you're going to file.
So are you seeing a way for this process to be beneficial to applicants and interested parties?
Both, because for example, a developer that is worth his salt is going to go to the neighbors anyway and try to ferret this out. This is just one layered process to bring, this is including citizens, because you want to hear where the trigger points are. This is what this meeting is about.
So, but I guess I'm confused, because I think I was hearing you say that, yes, people tend to start local, in which case we wouldn't have had communication yet with the district commission.
Correct.
And yet we're asking in this recommendation that we're talking about now to say to the district commission, you'll convene this stakeholder group. So it's a.
Well, I guess I haven't
I'm
heard
missing
it
something.
as the commission convenes. It's sort of like the commission, I don't know, also, Ernie's experience, I think, is largely in Chittenden County where there's a robust local process that's pretty much, I've been to several of them just because I happened to go to the MPA that night, and that's where some of them happened. That's a neighborhood meeting. I'm assuming it's quite different if you're developing something in Lamoille County where there isn't maybe the same local overlay. And it could be to me that the commission would be looking to make sure that this has happened. So if it's happened at the local level, then the commission goes, okay, there's already been the informal citizen review. But if there hasn't been, then they step in and require.
Yeah, Act 250 should not take on an extra role. You should be able to facilitate the role that you have. That everything is being done at the local, and I'm all over 20 different towns.
Okay.
So I've been there, done that. So you do a lot at the local level. What I'm hearing is that as you're approaching the application period, before you go full on and do all sorts of formal, there are appropriate times when having that meeting with the state group is key. Because you're going to already have approval from the city, and the towns and the community, so I don't think you're going to need to bring those people all to the table unless they're required. It's a customized thing.
Diane, did you have
I,
something?
I was just gonna add, not necessarily pertinent to the notice or the convening, but that it might be useful to think of the projects that would require this process to be similar to major projects in the Act 250 process. Those are the projects that are thought to have particular adverse impacts that would need to be mitigated and or issues that would be relevant to neighbors, et cetera.
Aaron?
I think that's a really, I appreciate the suggestion, but I think you might wanna refine the major projects further. I mean, you could look at thresholds in terms of using construction cost for a development to represent the intensity of the development. You could, for a subdivision, you could be, okay, like how many lots is a really big subdivision? You know, that would probably be a major. How many units for a housing project is a really big housing project? That would be a major.
I just wanted to make it clear that the process that I'm gonna be talking about is much more extensive than what he's describing, because what he's describing is still leading to a contested case. And I'm looking at it from the perspective of the citizens' interests and what can be beneficial from the citizens' perspective.
Yeah, I mean, I think having communication up front is arguably not, leading to a contested case, but that's great for later. Are we? Go ahead.
Well, I was just gonna ask you, we're wrestling with this now. If we get somewhere peaceful about it, does it make sense to then have Annette presenting her idea, or should we just ask her to do it?
Wow. I was trying to still understand what we were proposing, so.
Well, I understand that, but.
What are you making a
Well, I'd say Annette
recommendation
is
that
just
you wanna hear?
referencing some comments she's gonna deliver to us at public comment at 3:30.
Yeah.
And I'm not sure that, just get down, get the idea on the table.
Okay. What do you guys think?
I think it's a good idea.
Good to hear from Annette
Yeah.
now. Okay.
Can I, while she's getting ready, could I just add that the more descriptive you could be about what you would consider being a part of this process and the development, like what stage it would trigger, the more information and direction you can give to the district coordinator, so there's less personal interpretation of what your intention is, the better.
I'm hoping that this isn't gonna be more than 15 minutes, but.
It's online as quickly as I can, and
Okay.
I've sent the
Did you
documents.
bring
and
copies?
I've got copies.
Super.
It's also online for people that are looking under John Brazen.
Yep. Should read by morning.
You want it pulled out?
No, So I'll give a brief introduction. My name is Annette Smith. I'm Executive Director of Vermonters for a Clean Environment, which is a grassroots organization that has been around since 1999. And we deal with all kinds of development projects, and in particular, the interface between industrial and residential agriculture. And I have been a student of permit reform for way too long. I dug up a report from the 2002 Permit Reform Committee that Senator McCormick was on. I've got a report on rebuttable presumption. I have been listening for years to the same arguments over and over again. 2 bites at the apple by developers. The lack of money for citizens. The siloing at ANR that never gets into Act 250. De novo, on the record, we've heard these things over and over, like every 2 years in the 2000s. So, in the last 9 years, I've been working almost entirely with PUC processes and renewable energy. We had the benefit of actually having a community-based stakeholder process that was facilitated by Conservation Law Foundation Ventures. They have a separate organization back in about 2005. And this was not a new project. This was about the operation of the ammonia plant in Florence and the impacts it was having on the community. What led up to it was insane. It was all kinds of different processes, all of which failed, including mediation. which finally got everybody to the table out of frustration. We had the North American president of the company. More recently, with Representative Dean in the process, we worked on Agrimark's land application of 100,000 gallons of wastewater every day. And highly contested A&R permit, the company agreed to come together and work, and it took about a year, and they put some money into it. So all of this informs what I am presenting to you today. There's the last 2 pages of the document are the 2 sort of proposals that I have to bring to you. One is they both have sort of yellow background. So there's problems with the PSB process I wrote by accident, but it's actually, somebody asked me to write something and I misunderstood what they wanted, but it does lay out, it's a nice accident, it does lay out the problems with the PUC process, which are extraordinary. And unless you have $100,000 to put down on the table, you just might not go there. And when I hear the time frames on Act 250 and people complaining about them, oh, you haven't seen anything about the time frames for getting an approval at the PUC process. So I won't go through all of this, but this recent dust-up over the anonymous letter in Green Mountain Power and the rate case has really helped me understand even better the value of the PUC process for rate cases and for all the paperwork and lawyers and filings and all that. It has no place in land use. We're the only state in the country that has a PUC that does land use. And we're also the only state in the country that does not have an independent consumer advocate. So, leading into the discussion about an alternative process, at the bottom of that page with the resolution on it is the statute that Title 10, Section 6085E, that grants the authority to promote expeditious, informal, and non-adversarial resolution of issues, require the timely exchange of information concerning the application, and encourage participants to settle differences. So this next page is sort of my senior thesis on the regulatory process and a way to insert in the front end a community-based stakeholder process. Now, this is not the same sort of thing that Mr. Pomerleau was talking about. And I had another opportunity back in 2011 when I applied and was accepted to participate in a 3-day workshop that was called Facilitating Wind Energy Development, and it was entirely to teach wind developers how to do community-based stakeholder processes, because they said you're not getting your projects done, you're not working with communities. And so the founder of Consensus Building Institute, who was also the founder of the Harvard Alternative Dispute Resolution Program, was one of the teachers, and was really fortunate to participate in that. I've asked 6 wind developers since then and before then to actually work in a community-based stakeholder process. The fundamentals of a community-based stakeholder process is that you need a facilitator, of which I think that with some training, district coordinators and commissioners could be, and then you need the notification so that you make sure that all the parties are there. In the OMIA stakeholder process, we had at local town, we had A&R, all the citizens who were affected. Not all of them, I mean, certain citizens chose to put the time into this. And it's not just, let's look at what the proposal is, but it's a way to lessen the burden on the community. It's a way to assure that there's more buy-in in the experts that are hired. And so what we did with the OMIA stakeholder process and what this community-based stakeholder process is about is the first step is to figure out what it is that we need in terms of expertise. Then you issue a request for proposals. We interviewed 4 different firms, and we then all agreed on who to hire. And we hired a hydrogeology firm and a toxicology firm. And then we, and this is what's called joint fact-finding. So rather than the experts hire their own, or the developer hire their own experts, and the other side hiring their own experts, where you have these dueling experts. And in Vermont, we have a very small pool of experts, so the usual suspects always show up for the developers, and the citizens are scrambling to find somebody, and they don't have any money. This means that the developer's still gonna spend the money, but they are going to pay for the experts that everyone agrees on. Citizens will then have more confidence in the results that come out. It was a real game changer in the OMIA process that we went through. The company goes around saying, you made us a better company. It really changed everything. And they will say that, and I've heard them say it. So it does take time. Now, let's use an example. Let's say that Nestle wants to come in and extract lots and lots of groundwater for bottling in a community. So, okay, if somebody is going to come in and do that, then don't you want to have some relationships built? Don't you want to have something in place so that after the fact, if somebody's well goes dry, that you know what to do about it, you come up with a plan? This was also the opportunity we presented to Green Mountain Power, even on a limited basis for the Lowell Wind Project. Let's just do it on noise, so that if there are noise problems afterwards, then we have built relationships. And this is one of the things that these processes do. It builds community. And so, but it's very hard to get the businesses to do this. It's also very hard to get the citizens to the table. However, if there are incentives, my process involves a carrot and stick approach. And it also goes to address other needs that are long overdue in Vermont, and that is a counsel for the public or a public advocate, and an intervenor funding. Intervenor funding is something that was discussed in the Act 174 working group about the PUC process. Senator Lyons was supportive of it. It didn't get through, but it is something that is done in other states. And so the idea is that if everyone on these big projects will agree to come together and work together, then that it minimizes the cost for everyone and can potentially, not in every case, but can potentially improve things. On the other end, if they don't want to do it, then okay, go to a contested case. And my recommendation is to create a professional land use panel, get away from environmental court, except for local zoning appeals. They haven't figured out how to eliminate environmental court for those, but go back to that. I put in here 5 members and it could be varying expertise. And so then if people don't want to do the stakeholder process, then the developer puts up a percentage of their project costs for the intervenor funding so that the citizens can hire experts. And we have however you want to call it, different states call it different things, but a real public advocate or a counsel for the public, or a way for the public to have a legal representative in. And then you have one contested case, not two, not 2 bites at the apple. You have one contested case that is a real contested case because both sides have the ability to put on their case, and then there's one appeal to the Vermont Supreme Court. So that in a nutshell is my proposal, and in moving land use from the PUC would retain the issues that PUCs traditionally do: reliability, need, interconnection, all those things that really belong at the PUC. I believe our PUC has been tremendously disadvantaged by having to handle all these land use cases. It's not their business. The process is a nightmare for any citizen who tries to participate. And so building on what we already have, regional offices, coordinators, all of this is possible. The author of this book, which John showed you last time, Resolving Land Use and Energy Conflicts, is written by Patrick Field. He is coming to Vermont regularly to do some facilitating of things on agriculture, and he would be very happy to work with us. They want to formalize and help us formalize a community-based stakeholder process and joint fact-finding so that it can move things forward. So the option is choose to work together in our communities, or and by that build relationships and create better projects, or if you want to fight, then empower the local people to have that fight. And that the deciders will get better information.
I had a question actually for Aaron, something I'm reminded of. Can you remind us, Aaron, the difference? I know we have minor application process through Act 250. Can you just give me the summary of the difference between a normal application and a minor application?
Sure. When an application is filed, a judgment is supposed to be made about whether it's a major or a minor. And the basic concept is, the commission looks, with the coordinator's significant help, to see whether there's the potential for significant impacts. A minor, and they also, I think, I don't have the whole standard in mind, but in any case, if something is judged to be suitable for a minor, there's a notice with a proposed permit that goes out, is my recollection. And then people have an opportunity to request a hearing and or submit written comments. The district commission can on its own motion decide, even after having issued that minor notice, that, well, no, we need to have a hearing on an issue, or people can request a hearing, and if they demonstrate there's potential for significant impact, the district commission would generally give them a hearing. And at that point, on the issues that are set for the hearing, the process becomes like a major, which is, notice, hold a hearing, present witnesses. A major can also include a pre-hearing conference where you set out a schedule, and you might, there are multiple possible iterations within a major. A major can include pre-filing written testimony or not, things like that. But it's much more formal. There will be a hearing, and there's the right, witnesses are presented, and there's the right to ask questions. I don't know if there's anything I left out that folks from the board might have.
You give a summary.
One of the things that we observed on the numerous, and we had administrative process at A&R, we had mediation at Vermont Law School. When things changed was when we got the lawyers out of the room. No disrespect to lawyers, but, and I work well with lawyers, I like lawyers, but it really is an obstacle to solving problems, and it creates a dynamic that is counterproductive because the lawyer is representing the interests of the client. And so the idea of the community-based stakeholder process, Warren Coleman was in the Agrimark one, and I gave him a little hard time about it, but we let it pass. And he was he was working for Agrimark and was interfacing with A&R, and it made sense for him to be in it. But the role of lawyers in the district commission process, what my understanding, and Bruce Prost has said this, is that when Act 250 was first started, it was intended to be a place where people would, sit around the room together, like in a coffee shop, and talk things, and it was to be more informal. John Marshall wrote a paper not long after Act 250 was implemented, and Mark Blucher, whose father was on the original drafting of Act 250, shared it with me, and through it, I went through it, and I came up with this diagram showing what the original intention was, who all of the various parties were that were intended to be at the table. And if you actually look at the interagency review, that's gone. A&R Forests and Parks, that's gone. Regional planning submits a letter, doesn't really participate. Local planning, again, not that involved generally. And select board, these town boards, we're even having trouble filling them these days. So what you get down to is those whose interests are affected, directly affected. And so while it wasn't really intended that the local citizens were supposed to carry the ball, that's how it has effectively worked out. And the local citizens will find themselves in these district commission hearings up against an applicant represented by a lawyer, and it takes it away from the whole ability to have that more sort of sitting around the stove at the general store talking about what are the issues and how can we work through them. And so I'm not happy with how the district commission process has been used in many cases now to put on a full case, which then the developers complain they have to do it again if there's an appeal. And I don't recommend any citizens go to environmental court. If they can't get what they need at the district commission level, then they might as well just quit, because environmental court has the same problems as the Public Utility Commission process. It's too legalistic, you have to have lawyers and experts, and it costs a lot of money. And Vermonters don't have the money to pour down this drain trying just to protect their own interests. And the wind issue is probably the best example of how disenfranchised the local people can be and how beneficial it would be for everyone to sit down together and actually work through the issues. And it's not just about getting to yes. I asked Dr. Susskind, is this about getting to yes at this workshop I went to? And he said, no, absolutely not. No always has to be on the table. It's not just about getting to yes, but there are a lot of projects that get approved right now that should be said no to. And so through this process, you may find that developers will realize that it's not going to work for them. So I appreciate all that you are having to take in, and that what I'm presenting to you is much bigger than what you are being charged with. But I really want you to consider some structural changes that will enable more collaboration and less fighting.
And are you going to submit your diagram?
It has been submitted.
Okay, great.
So you'll find it under John
It's
Brayden.
online under public comments, John Brayden.
Okay, great.
Thanks. So,
Dick?
The idea of a kind of kinder, gentler, less legalistic approach, that means one thing to the person who thinks his rights are being violated, and something else entirely to the person who is getting their way. I mean, the developer, for example, I mean, has investment involved and a perception of property rights. And the quasi-judicial, the quasi part is to keep it neighborly, but the judicial part is to protect people's property rights. So do we not lose some of that by making it less legalistic?
no, because if the developer says, I don't want to have anything to do with this, then
They walk
then
away.
they don't just walk away. No, they put up the intervenor funding for the neighbors so that they can actually participate, which is the incentive for working with the community, because developers aren't going to want to put up money for their neighbors to hire their own experts to compete with their experts. So this won't work unless there is a carrot and stick approach. And overall, even if you wanted to throw out the idea of the community-based stakeholder process, in the big cases, whether it's at the PUC or whether it's in Act 250, we need intervenor funding. We can't expect these businesses that come in with all the money in the world, and at least that's the perception, and all the ability to hire all the usual suspects, that then really impoverish our communities with the hundreds of thousands of dollars that it takes to fight these cases. I mean, when I was dealing with the idea of only opening a new mine in my town, it was called by VPR the mother of all Act 250 cases, because there would have been experts required on almost every single criterion. And I was looking, and this was back in 2004, I was looking at having to raise $250,000. And that's the kind of money that gets spent at the PUC now. And so is there a way for us to find a more fair process, and one that if some of these big developments that are sort of tied to like where the water is or where the ore is, if those projects can be done in a way that brings communities together rather than creating winners and losers. That's the piece that I'm trying to get at.
Any more questions for Annette? Thoughts? This is, what's that?
Thank you.
Yeah, thank you.
Thank you.
Oh, and then what's the name of the book you were talking about? Resolving Energy?
Resolving Land and Energy Conflicts. They sent it to me because I saw it was $104. Yeah, I want it back.
Better put Annette's name in it. Okay, still on a straight path here. I think we should just keep going forward with this information now front and center in our mind. 11:42. Look at the next bullet. Coordinate, interface with other permit and planning processes.
Okay, did you reach a conclusion on the last bullet?
No. Did you have a proposal for a recommendation?
No, so are we going back to it, or?
I guess that's what I'm proposing. I mean, if you guys are ready, does someone have a coherent thought on a recommendation from what we've
Well-
just been discussing?
Coherent is a high bar. but-
Yeah.
I guess the reason I asked about the minor application is that, it's going to be realistic for us to build on what we already have or augment what we already have. And I'm wondering if there would be any logic, people would tell me doesn't make sense to have a stakeholder process, something like we've been discussing, and if that happened to everybody's general agreement, then the application could be treated as a minor, which would be an incentive, I think, as I'm understanding it. And would that be enough of an incentive? Then, because the way Aaron, I hope, please listen, but as I understand, the minor application would be the state making sure its needs, the criteria, all those things are there. But in another way, you would have determined that the stakeholder process sort of has handled the public and the neighbor concerns, because it's, I know a minor application doesn't have to stay minor, as we've understood, but I wonder if there's a logic to webbing some iteration of a stakeholder process together early on. It's community discussion, and if it was deemed successful, then you shift to a minor application. I've thought of that for about 15 minutes, so.
Aaron?
Well, my first thought, just as someone who's has been a party or represented a party and also been working for the former environmental board, is if a success is very likely to lead to it being a minor, whether you say it automatically gets minor or not. Because if success is defined as lots of people reaching agreement, then that means that a lot of issues have been addressed. And that doesn't mean all issues have been addressed, and the district commission will see that, but presumably the stakeholder process has included the various state agencies that represent resource interests. So, but if it doesn't work, or if it hasn't worked for everyone, then automatically making it a minor could end up.
You'd have to end the stakeholder process with everybody signing off in some way in order to earn your expedited minor, or that was conceptual.
I understand the point. Well, I guess the main point that I would want to leave you with, my first thought is, chances are really good that a successful process would lead to a minor.
Okay.
Because a lot of the I's and T's, I's dotted, T's crossed. I was about to talk about crossing I's. But other folks may have another perspective. That's just my first thought.
Greg?
Yeah, one concern I think that I'm seeing is, assuming that all the parties are able to come to some kind of consensus, then I think theoretically the project would be reviewed as a minor. But the concern I'm seeing is, even though the parties might come to consensus with respect to certain elements of a project, it doesn't necessarily mean that all of those elements meet the criteria. And so the commission is still going to have to look at whether the project in its entirety meets all 10 and sub-criteria.
But isn't that what the minor
It could be.
That's my point, is that the minor application, this is just spitball, but I would assume that the district commission says, we're satisfied, the public seems satisfied, now we have to make sure the criteria are met, that's the state's role. And that's why we're not saying you don't need any application, but you get to go through in a minor.
I think best case scenario, that's where you end up, but the commission may need more evidence still in order to get to the place where they could sign off on a minor and issue a permit, and that may require a hearing. It may not.
Okay. I think what Greg is saying more eloquent in a clearer way than what I was trying to say is, I think the commission may need that room to exercise its independent judgment on whether what has been given to it actually does meet the criteria before you go into the minor process, because that's the judgment they make.
I see.
I think that's what you're trying to say.
If you're in a minor application, you can't, a minor process, you're not. You can still call witnesses, you can still have experts, right? You know?
Well, the way it works is an application is filed, and a judgment is made about whether it qualifies for a minor or not. And that judgment is in large part based on all the evidence is there, and it looks like it satisfies all of the criteria.
So that's not the right incentive.
It may not be, I'm not seeing it, but that's, folks may have other.
And
I think the stakeholder process I'm talking about would, especially facilitated by the district commission, would be entirely focused on that. I mean, when you go into a hearing right now, you'll find that the commission's already limited the criteria that you're looking at. And this group would do that too. And then you would hire experts on all the criteria that were necessary to be discussed. And so it would be, this is with the involvement of the commission, not outside of the commission. And so that they would be tasked with assuring that the criteria that are deemed to be relevant to the case would be looked at.
Yeah, so, and I just want to make one other kind of, understand this a little bit more. You were really proposing this specifically for energy siting, and that would be energy siting projects of a certain size, I assume.
Well, actually, I wrote that in January of 2015 and presented it to Representative Klein's committee, specifically with the idea of moving energy siting, but this could be done without doing that too. But yeah, there would be a threshold for a size of project, which other states determine intervenor funding, for instance, based on a certain monetary value. So that, I think that a review of cases and what cases have cost a lot of money. I mean, I did focus groups with citizens in 2003 and learned how much money, on average, citizens back then were spending about $100,000 for really heavily contested cases.
So this also brings, I mean, one of the big things is that just the general concept of bringing energy siting into the land use portion of energy siting projects into the Act 250 realm and out of the PC. And that's the basis of this proposal, so. Okay, should we go back to my original recommendation?
Yes.
We keep
Yes.
moving on.
I plead mercy.
It's good, no, that was great, very good to explore that. Here we go, something else light, interface with other permitting planning processes. Coordinate interagency review of Act 250 applications to include utilization of the capability and development plan maps in order to guide public investments, to evaluate the impacts of projects. He'll be NRC's in here listening, because you're gonna need to talk about the recommendation.
John's here.
Yeah, he's just outside, I
Yeah,
was.
he's right
Okay,
there.
here. Okay. Can you
Oh,
hear?
sure.
Yeah.
Birthday.
Oh.
Here. John, that's a reference.
Oh,
So-
I can't think of any better way to spend my birthday.
Yeah, I love Act 250.
We know you do, that's
I
why
asked
we
for more Act
planned it.
250 for my birthday.
You got it. All right. Coordinate interagency review of Act 250 applications to include utilization of the capability and development plan maps in order to guide public investments, to evaluate the impacts of projects on existing state investments, and to guide state planning decisions.
So really simple.
What?
So Peg, you help me out with this one. This is a really planner, would you agree it's a plannerly sort of an issue, so.
And it's in the planner ones too.
Yeah, and Aaron as well, who's been watching this for a long time. So the capability and development plan is part of Act 250 now, but it's really never been brought to life. It hasn't had really substantial meaning in terms of how applications are evaluated. And the idea was basically what you just read. It was basically to have a planning process and maps to basically help understand where public investments are made, where our critical resources are, and have that inform how the criteria are implemented, especially the growth criteria and the planning criteria of Act 250, which are mostly in the nines of Act 250. And so we ran out of time in terms, this is a very complicated issue. And so we did not have a specific brilliant idea of exactly how to do that.
Yeah.
But we do feel strongly, and we've talked with the planners about this, that there's got to be a way to integrate the mapping that we have that's so much better now, and the resource information that's so much better now, and the work that we're doing on where we want growth to happen versus where we're concerned about impacts on working lands, where we grow, into the criteria. So I guess the recommendation we'd be looking for is to work towards that. I think we really do need to bring people together to figure out exactly how to do that. But and Elizabeth Courtney's here as well, and I'm sure you've thought about this a lot over the years. But that's the idea. We don't want to lose the opportunity with this commission's work, if we're really modernizing Act 250, to do something about this. I don't know exactly how to do it.
Okay, thanks,
It's really
that's helpful.
complicated.
Aaron?
So last week, similar ideas were discussed in the context of some of the other tasks. And based on what the discussion was, we wrote up changes to the report and potential, the beginnings of language, frankly. And so, I mean, so you have some more specifics, at least in other task groups. It's not really related to this particular task of, interface with other permit processes.
Right,
But,
that's a good point.
in task group 1, we asked to light up some of these issues in terms of, the overall relationship of Act 250 and planning.
Yeah.
And there were other things, so, I don't know, at some point we need to go over those. I don't know if now's the point, but I just wanted to make sure you're aware that there's a bunch of stuff already.
Right. And I think putting words in the mouths of some folks who weren't even here, but I think the recommendation was to move in this direction last time, so we support that. Is that fair to say, amongst those present? Okay, great. So whether that belongs in this section or not, I'll let you all decide as the drafters of the report, but we do support this in a general, conceptually, yeah, generally support that.
We're doing a lot of cross-referencing, so we can always do that.
Yeah. Okay, establish a well-coordinated planning framework across jurisdictions in support of more effective planning and development review. That's from the Planners Association.
It's the same, pretty similar thing, right? Different way of saying the same thing. Coordinate interagency review, it says on that one, it says well-coordinated planning framework across jurisdictions.
Well, one is within the state government, I think, isn't it? Interagency,
Yeah.
and the other is planning agencies. Peg?
I spoke to this a lot last time, and I do see some proposed language. So Peg Huff for Vermont Planners, things that were mentioned were that we don't have as active or may not even have an Act 250 club that meets on Friday mornings to review all applications and really have an active interagency review of Act 250 applications.
And that was called the Development Cabinet, is that right?
Well, was another
different
entity
thing.
under the Dean administration that established that was a development cabinet, and there was a sub-cabinet as well that was very active. It was a weekly, bi-weekly kind of meeting around controversial projects as they were coming through, way ahead of time, 6 months ahead, to work with the applicant to some extent to try to help smooth that process. And
So can I just time you out, because we have a lot to do today. If you think we've already addressed that in the conversation we had last week, and that when we come back through to the report review, we'll hit this again, just let me know.
I think the
'cause
only
it'd be
thing I
good to-
didn't get to say last week that came from our recommendations was to establish an interagency task force or work group to review and update, the state land use and development policies and related requirements. That's in Title 24 as well as in Title 10. If we're making, changes to Title 10 now, to make sure that we're also looking at Title 24 on the local process to get those coordinated.
Everyone,
Just a question.
yeah.
How binding, if at all, is the plan?
How binding is which plan?
Is it a question for
Any of the
NRC or-
plans that are
Oh.
referenced?
Well,
They don't, they're not in other words, compliance is not mandatory. It's not as though the planners have an authority to compel or prohibit.
Towns are not required to plan, they're not required to submit it to the Regional Planning Commission for review and approval. We're very, voluntary.
If they do plan,
They do, if they
it
do.
still does not have a compulsory
Right.
quality to it. Plan.
Conformance is required in Act 250.
Conformance of,
With the plan, but the
With the
plan
plan.
itself, the review, the town plan itself doesn't.
so it's through Act 250 that it has its authority.
Well,
Yeah.
the plan has a compulsory element in Act 250 if conformance is required, is the
Yeah.
point that that's been litigated as to how specific the plan provisions have to be. The main point of the plan is to provide the basis for adopting land use bylaws that are supposed to be consistent with the plan, and those are binding in the municipality.
But the approval of those, does it have to be an approved town plan in order for Act 250?
That was the recommendation we made last.
Right.
Yeah.
So, and we agreed to that. Yeah, okay, thanks. So I think that one's, we agree with it and it's supported. Am I hearing that from everyone? Okay.
And that's the interagency task force to review and update state land use and development policies and related plan requirements. Page 8. Which one are you talking about?
I thought we were talking about a well-coordinated planning framework across jurisdictions
Oh, okay.
to support a more effective planning and development review.
Thank you. I thought she had mentioned something else.
She did, but we already included it last time, I think. Although, did we talk about last time requiring plans?
We did.
And what did we come down, what did we say?
I thought you were supportive of that,
Yeah,
but
we were.
that's what is written in here. That doesn't mean it's binding.
That's great, good. No, I wanted to just make sure that was in there. Dick?
Yeah, to
Sorry,
start with,
requiring plan, I'm sorry, excuse me, I misspoke. Requiring plans to meet the goals, the
Yeah.
planning goals.
Not requiring plans.
Not necessarily.
Okay.
So there's two different things. A municipality may have a plan.
If you have
Yes, I know, that's what I was trying to clarify. Did we require that every
okay.
municipality have a plan?
We didn't talk
No,
about
you
that.
didn't, I didn't think you had necessarily gone there. I thought you had gone to the point of saying if you have a plan, it meets it has to meet the planning goal, which it doesn't have to.
Right, okay.
all of these bullets on planning, this looks to me like Act 200. I thought we already did that. Didn't we already do that?
Well, it's
30 years
on the
ago?
books, it's not implemented in a vigorous way. I think that's the core of these recommendations.
So why is it not implemented in a vigorous way? What does that mean, and how would we?
Well, I mean, Peter and the RPC perspective should jump in, but I mean, state planning has waxed and waned over the years. When Act 200 was when it was enacted, there was a robust effort for state agencies to plan, and then over the years, different governors have had different feelings about planning efforts at the state agencies, mostly not really positive feelings, and wanting to put a lot of resources into state agency planning. And so I think that state agency planning is really dipped from when there were a lot of state agency planning efforts that were going on, and good coordination between the agencies, and then better coordination with the RPCs. I mean, the idea was that there would be state plans and there would be regional plans, and they'd be consistent, and then local plans would be consistent with the state and the regional and the state plans. And
But, excuse me, to the point of if it's in statute right now, it's not happening? Is it
Well-
required in statute? Peg?
Well, is the point I made last week that for $50,000 piece in appropriations, the Council of Regional Commissions was gone, no more staffing,
Right.
no more, and that was the entity that reviewed state agency plans to make sure, and also the regional plans. So it was, without having that, I mean, the regional plans are reviewing the local plans, so it's not really fair. The other entities are doing what they wanna do.
Sorry, John, I cut you off.
No, it's okay. I mean, I agree with Peg. I mean, I think it's a matter of funding it and then directing saying it's a priority for this planning to go on and to keep the plans up to date, to have the agencies coordinate and to have the system work as Peg described it.
And statute required currently.
So I'd have to check. Some things were pulled out during the Douglas administration. Some threads of that woven tapestry were pulled out.
Yeah, I agree.
There's no council or regional commission that reviews regional plans, if that's what we're.
That was the thread.
I'm not sure if it was taken out of statute.
I think it was.
Okay.
Annette.
I want to provide an example of what maybe you're trying to get at in some ways here. I serve on the Regional Planning Commission, and we recently approved a plan that does not meet the state's goals. And it was a fight among commissioners and those of us who wanted to keep the plan, not approve the plan because it didn't meet the statute, lost that vote. This particular town now has an approved regional plan that doesn't meet the state goals.
As a approved town plan.
Excuse me, it's approved town plan that doesn't meet the state goals. And they seem to be considering actually pulling out of the regional commission. And so there's a whole dynamic that I'm seeing going on there, that if the more sort of onerous the process becomes, towns may just prove to pull out. So the idea that you have to have an adopted plan that conforms to the state statutes might be the way to go. Because we have an adopted plan in our region that doesn't conform to the state statutes, but it is adopted.
Interesting.
It's also not really appropriate to say, or really accurate to say that state agencies don't plan. There are a lot of plans that they're required to do for their federal agencies. And we were headed towards, in that whole planning process, was to use those plans and just add on to them so that they also met our state goals.
So is it fair to say that we're doing a lot of planning, but we just need to kind of coordinate it better? And that would be a solid recommendation for our group to put into our report.
Give it some teeth.
Yeah, I agree. Give it some teeth, bring back something like the Council of Regional Commissions, have accountability for the compliance and make sure that they conform in the way that they're supposed to, and have a process that demonstrates that.
That's in the draft.
Yeah, okay.
It's in the draft report, is that what you're gonna say, Aaron?
Well, in the draft report, there's, based on your discussion last time, there's a recommendation that regional plans be reviewed for consistency, as well as municipal plans. Municipal plans would be reviewed by the regional commissions. In putting together draft legislation, what I did was actually, think, well, rather than create a new entity, perhaps the Natural Resources Board could be reviewing the regional plans for consistency, since if that's gonna be a reason, if they're gonna if there's a link to Act 250, because I thought you were talking about, we need plans that are approved as consistent with the goals in order to be applied in Act 250. The Natural Resources Board may feel like it doesn't want the job, or that it doesn't have the resources for the job, I understand, but creating a whole new entity has its own
No, I agree.
issues.
Yeah.
I was wondering
That's
the
good.
same thing.
Okay. Elizabeth.
I would just want to toss in here the cautionary measure. The reason the capability and development plan was rejected early on in the life of Act 250 is because of the perception that it was state zoning regulation coming down to the local municipality. And the more you can build in the sense of this is a tapestry being built from the local up as opposed to the Montpelier down approach.
Just to add on to that, the Council of Regional Commissions was a representative from each of the regional planning commission, and only 3 or 4 representatives from the state agency level. And that was an amazing educational experience, as well as just the participation across the state and understanding across the state being built.
And how often did they meet?
They met, I think, once a month for a while, and then there was no more money for donuts and coffee for the people who came all the way from Bennington, and then there was no more money for staff, and then there was no more money for even the executive officer.
How long did it exist? Does anyone know?
1989 to about 1993, not very long. We hit a recession. We really hit a big recession right now.
Okay. Are we kind of covered on recommendations in this arena?
It's crystal clear.
You've got some drafting to, that was your target when you came around to.
Okay, when we get to it. That's what I'm
To-
wanting to
to
get
throw
to it.
darts at the target,
I'm
yeah.
definitely wanting to get to it, so if it's already in our draft report, then I don't know that we need to do it again. Is there enough in the draft report to toggle us back to this? Sounds like there is.
I think so.
Okay, are we ready to go straight to appeals?
Can I just interject? There is one piece you didn't discuss, the strengthening of presumptions of other state permits.
yeah.
The strengthening of presumptions for other state permits, you
Oh,
haven't
yeah.
addressed yet.
Thank you, yes, that big one at the bottom, that Dick didn't really mean to lump with Act 200. Thank you. So strengthen presumptions of other state permits. To enhance the presumptive effect of certain state permits, we recommend limits on the evidence that can be used to rebut certain presumptive permits. This change will make the Act 250 process more efficient, predictable, and will not result in any substantive loss in the review of the project's impacts. This is from the executive agencies. We've actually talked about this a lot and taken a lot of testimony on this one. You want to give us the 2-minute summary, or if you have anything to add, just, or people have questions?
Sure. Billy Coster, A&R. Currently through rule, the Natural Resources Board accepts certain state and municipal permits as a rebuttable presumption for certain criteria. So you can submit your stormwater permit to show that you address stormwater issues associated with your project. There's not a lot of, my understanding is there's not a lot of rules or rigor around what information can be introduced to rebut that permit in the Act 250 environment. And what we're proposing is just limiting what evidence can be introduced to rebut that presumption, so that we're not relitigating the same issues that were litigated when that permit was issued. And those limits would only be applicable if that original permit was noticed, there was opportunity for comment, and there was opportunity to appeal. So the original permit needs to have access to the public to engage, comment, and appeal the decision. And if that exists, then essentially that permit can't be relitigated through Act 250. And Evan may be able to provide a little bit more detail about what the narrowing of evidence entails.
Sure. So I think Billy summarized the bones of it pretty accurately. I mean, right now, Act 250 Rule 19F sets forth the standard someone has to meet in order to rebut a presumption. I think the goal of the proposal by the administration is to add an additional component which defines the types of evidence that is admissible when trying to meet the standard that currently exists. I think the goal is to try and reduce the time and the cost associated with relitigating positions. So theoretically, right now, someone could obtain a permit from A&R, and then that could get appealed to the Superior Court. Then it could again get appealed to the Vermont Supreme Court, and while that's happening, the same conversation or debate could be occurring in front of the District Commission, which could get appealed to the Superior Court, which then gets appealed to the Vermont Supreme Court. So that's 6 proceedings in which an opponent to a project might be presenting the same evidence and arguments to try and either condition or condition a permit or get a permit denied. Is that repetitive, and does it force people to spend money unnecessarily? I think we heard some testimony that it's like $100,000 could be spent by opponents to oppose a project. So if we define what types of evidence are admissible to rebut a presumption, does that increase cost savings, decrease the amount of time spent having these conversations, and encourage opponents to a project to spend most of their energy in the A&R permit process when they're opposing an A&R permit that might give rise to a presumption?
I just wanna give commissioners a minute to process or have question or discussion, and then Jerry, I'll let you speak, but do you guys have initial thoughts or reactions?
I'm sorry, I suppose I should add one more thing as well. I think what the administration tried to do was adopt the type of evidence that would be admissible if someone was attempting to obtain a new trial in front of the court. So the idea is we're not going to have the same exact argument. You need to come forward and explain why there is some type of new evidence or argument that wasn't discovered previously that you were unable to present to the agency in contesting their permit, that now you have in your possession and you want to present to the district commission. That was the rationale.
Thank you. Jerry?
So my question was, how does the presumption that you're discussing differ from the deference that we've heard about?
Yeah, so the idea is that the proposal from the administration doesn't change the standard for rebutting a presumption, and it doesn't change the technical deference that would be given to the Agency of Natural Resource. It really is more about what evidence is relevant and admissible than changing the technical deference due to the agency or changing the standard for rebutting presumption. Those two things remain the same. This is more like a rule of evidence than anything else.
If I could just follow up, I mean, I think this goes back to an earlier issue. These issues are somewhat nuanced and complicated. When you were talking about public participation, and we were talking about particularized interests, that's from the bottom up. And the public is learning really quickly that they can only get involved in certain issues. But now, in the last few years, they're learning that once they get out, they run into not only a presumption, but a deference to the technical expertise, so they can't really participate unless they want to hire a lawyer and experts for no reason. You're running up against an Act 250 process that is been narrowed and narrowed and narrowed by state agencies and the court. So that there's very little that if I were talking to a neighbor or an interest group, that they can legitimately prevail on. And so Act 250 has become more of a process than a substance. And we've seen this narrow really considerably, and you've just heard that it's not just the presumption, it's a technical deference. You can have developers put money aside to fight these things, but why would you do that if you know you're going to lose? And I've heard lawyers in the bar talk about this. I'm just not going to recommend appeals anymore. Public interest is going to shrink significantly.
So you're posing this suggestion, is that what you're?
I'm saying that you need to understand that the presumption has been around for years, decades, and we worked with it. Anytime you go up against the state, you better have a good case. Because the judge, whether it says presumption or not, the judge is going to look at the state, and they're going to know that they have some smart people. They have some political issues too. But when you have this technical deference, it pretty much wipes away your arguments.
Ernie?
It'll come as a shock, I'm not fully in accord with that. This is not narrower.
But that's not citizen input.
But this is into A&R, okay, that's what we're talking about. And so I agree with the administration, I agree with A&R. We've worked diligently over the last year and a half, 2 years, putting this on the website, getting the information out. The real issue is bring it all on, but bring it on once. The way it's set up now, you get 2 bites at the apple. There's been accusations that the engineers that we bring in, just because they're paid, they will do what we say. It's just fallacy. They're Vermont, they have licenses with the state. They have to go in. To keep their license, they have to meet the needs of A&R. The levels that we have to go through are extraordinary, and the review is extraordinary, and it's in detail, and it's a variety of things that are, could be a half a dozen things or more. They're reviewed, and the process that they've set up, it's open on the web, it's reviewed. The position that I think I'm hearing, and I agree with, you've got to testify against something at that level, even at a minor position, just to make us go through that for that length of time, get all the A&R permits, see nothing wrong, and then bring it to Act 250, and then get hit again full on. There's duplicity there. I think what you're hearing is that we are willing to go through any level. We have never once, from the development community, said strike that permit. It's not where we're coming from. It's make it simple, make it fast, open it to the public, but do it once.
So,
No, and that,
The idea that there is a public, hearing words like litigation and testify at A&R with permits, it just doesn't exist. From my perspective, working with citizens on numerous cases, A&R is like a brick wall. And the only thing that you can do is review the permit and submit comments. Now, in the past, it wasn't quite that way. I remember we were working on a rule, and all the parties were brought into, and it developed a good rule. But it's changed and become much, much more difficult. And so I know a lot of really fine environmental citizens in Vermont who have stopped commenting to A&R on things. I have stopped commenting to A&R on things because all you get back is a responsiveness summary, which John pointed out last week, is written by the person who wrote the permit. And we did try on a really serious environmental issue to bring in our own experts before the permits were issued to actually get input into it. Doors slammed shut. No way were they going to be interested in what our experts say. And the way that we interact with A&R is through public records requests. And citizens are outraged when they find out that a project they didn't know about until it was well formulated, they've been working with A&R for a year or two. And they feel like they should have had a seat at the table. We've asked for, can we have a discussion with the developer, with A&R staff, even without our experts, and that's been turned down. So I do have this report from December 4th, 2001 on rebuttable presumptions that Lou Borey did. I'll submit these things, and a report where they did look at rebuttable presumptions. If you read Supreme Court decisions, if you have appealed anything on any of these permits, doesn't matter whether it's a PUC or an Act 250 permit, they defer to the court. They defer to the state agency. They defer to A&R. That's where the expertise lies. And so to add yet more hurdles for and this report on the rebuttable presumption, they looked at the five cases between 93 and 97, and 4 of them were rebutted, which says A&R permits are not that great anyway, and if they're challenged, then they actually can be rebutted. But Act 250 is a place where we ought to be bringing those staff in to actually be able to cross-examine them, because there is no process right now that enables that.
thank you.
I just like to add, that report is over 20 years old. All those cases are over 20 years old. A lot has changed since that time. And the other point I'd just like to make is, as you've all discussed at length, Act 250 reviews a small segment of development in the state. Other state agencies issue significantly more permits than Act 250 reviews. That is primarily how the state manages environmental issues, is through permits that DEC issues. And if there is doubt with that system, if it's not serving the citizens well, then let's fix that process. But saying that it doesn't work so that we're going to rely solely on Act 250 to relitigate these issues that went through an administrative process, that's a challenge for us.
Well, how are those many other permits that you're talking about? And you're right, because a lot of development gets permitted without Act 250. How are those contested? How does a citizen get involved in the same way that
Consistent with Act 150, which you all passed a number of years ago, there's now different tiers of engagement, and this is something Matt Chapman presented to you about a year ago for different types of for permits. Almost all of them require.
That's the system that's coming online right now.
It's been online for about a year now.
Okay,
So it's relatively new, and I think we feel like that's in part why we're proposing this, because there has been improvements made in that regard. But permits are noticed, there's opportunity to review them, there are public comments, there's the requirement that we respond to those comments, comment by comment, and there is the opportunity to appeal. So it is a different process than Act 250, it's not completely dissimilar.
I think the issue that you're presented with is whether you, or the people still, the legislature or others, believe that Act 250 should have concurrent jurisdiction with A&R. I think that, you know, some people are calling it relitigation, some people are calling it duplication. That's a legitimate perspective, but the reason that we have the system we have today is that the legislature made a decision that there would be concurrent jurisdiction. And that Act 50 would have a supervisory role. The proposal that's in front of you would narrow that supervisory role to only when there's new evidence. So it is fairly close to not having concurrent jurisdiction, but there's something left. You could decide that, look, A&R is what we want to, A&R will deal with water quality, air pollution, soil erosion, and leave Act 250 for the issues that A&R doesn't cover. That's one way to go. But I think that that's the underlying philosophical problem here.
I just want to clarify that our proposal limits this presumption to just the issues covered by the permit. So if there are issues related to air pollution, water quality that were not addressed by that permit, that is absolutely where Act 250 can and should review those impacts. So we're saying, you know, if there's things outside of our permits, that's Act 250's responsibility, absolutely, and that doesn't change under this proposal.
Thank you. Mr. Weiss in the back has a.
Thank you. From a citizen's point of view, the advantage of Act 250 is that it's all together. It's one permit process where we cover all of the environmental resources, or many of them. If we go, as I understand, making the other state permits less easy to challenge at the Act 250 process, then we as citizens have to follow and track each and every one of those permits in order to be able to participate in it. And what I heard Mr. Coster say was that we submit comments and we get a response back, as opposed to Act 250, which is more of a dialogue, where we're trying to, it's not just a one-shot deal at Act 250. It's depending on the length of the hearings, there's some give and take.
Unless some of that very limited evidence comes in, the commission will not be able to look into the issues addressed by the permit. I think it's about almost as close as you can get to a dispositive permit without saying it.
Okay.
Just to answer, I think what has changed is because of Act 150, there's more process now. And there is, in addition to comment, the opportunity to request a public meeting, which is more similar to Act 250, where there is a dialogue where the permit writers get to engage with the public. So I think.
But to request a public meeting?
Yep.
That's different than, and what, I mean, that.
It's a meeting, not a hearing.
Absolutely. I'm not saying it's a one-to-one match. I'm just suggesting that, as you discussed at the very beginning of this process, Act 250 was initially created when there wasn't much other environmental regulation. There's quite a bit of it now, and that process is more robust than it ever has, and we're just suggesting that things be balanced to reflect that.
John.
So in my testimony last week, I provided information regarding my background. I was an environmental consultant, 2 different consulting firms in Boston, New York, and Vermont. Biasing testimony and biasing information in application documents was what I did, was what I was trained to do. When I testified, I was trained on how to present testimony in a way that was most favorable to our client, which was polluters. I worked on the Woburn site in Massachusetts. You've heard, there have been movies written about it. That's one. 2, I was a regulator, and I reviewed applications routinely that were engineer certified as meeting all standards, and they didn't. And they didn't. In fact, one one case in point was so egregious, I took it to the commissioner, who, by the way, the commissioner at the time was an engineer. And the idea was we would take this to the engineering board. He refused to submit to the board. I mean, this was egregious, outright misrepresentation. I actually wound up talking to the client fired the engineer. That's how I got to get that rectified. To represent that what goes on in A&R, and I've run these public informational meetings, we were trained to say they're not hearings, because as staff, early on, we didn't understand the difference, and we had General Counsel Mark Sinclair and John Castle and notable, competent attorneys train us on what the differences were. These are not hearings. Their agency staff are not required to be at those hearings to present, testimony. You can't cross-examine agency staff who are the drafters of the permits or the decision makers above them. In Act 250, I have witnessed on a number of occasions where agency staff were subpoenaed to go on the stand. The agency tried to fight that, and then when they relented and those staff got on the stand, they then told the truth as to what the process really was about internally, how the governor's office was involved, and directed the staff person in one case that comes to mind to issue a permit where there was not even a complete application in order to move this project forward. There was no basis to even issue the water quality certificate. So to make it more difficult for citizens to participate or challenge an agency permit, which at Act 250 is the most effective place for a citizen with no money and no resources to challenge an agency permits. And I would dare argue that the reason this agency currently, and every iteration of this agency, has come to this legislature and argued against citizen interests. Never have they come in and say, we want you to embellish citizen rights. Never, ever. It's always about reducing or eliminating citizen access to challenging agency permits, or making it most difficult and more expensive.
Thanks. I'm gonna just say, this is actually where we started today, talking about citizen, keeping it open and transparent and accessible to citizen involvement. I'm personally inclined to not support this proposal and say, you know what, if we have this one-year-old A&R process that has barely kind of got its feet under it, we can see how great it is after it gets going. But I'm not inclined in this moment to support that recommendation. Okay.
I agree, but I would just add the caveat that I would like to have full faith in the A&R permitting process, at which point this would make more sense to me. But I just hear it too often from citizens that it's.
One quick comment, not to turn it over, but most of my permits with A&R have nothing to do with Act 250. I go in there, they stop there. So they are clearly, and they've been repealed. So most of the process with A&R, you go through A&R and you're done.
They've
So
been
it-
repealed?
What?
You said they've been repealed?
Oh, and stormwater permit, yeah.
A
few times.
Appealed.
Oh, uphill.
Up here, oh, yeah, up here. So what they do already is do the whole enchilada, soup to nuts in most permitting processes. This is just different if it goes up to Act 250,
Yeah.
but it's already been done. That's
Yeah.
all. I mean, I know you're not gonna change it, but I'm just saying, there's a whole process already in place.
Thank you. All right, we're gonna take a break for lunch and come back at 1. See about, I don't know, 43 minutes.
Can you say test, test, test?
Test, test, test.
Right.
There's an open chair.
I don't know what's going on.
Sound like it's on.
Test, test, test. Why isn't this working?
Plug it in?
I think Tim is.
Use that microphone.
No, I